fine job, all of you, and we're going to get to some questions. So you still have time to submit questions using the Q&A tab in the chat window to the right of your screen, and we'll answer as many questions as we can in the order they are received. So I'm going to start out with one question directed specifically to Eric Bensky, and the rest of the panel, if they would like to weigh in on this with any follow-up thoughts, welcome to do so. But starting out with you, Eric, can introducing brokers rely on their clearing firm to identify and report suspicious transactions by their mutual customers?
Well, they can't strictly rely on them. They can work with them for it, but FINRA has emphasized that introducing brokers, in other words, brokerage firms that have relationships with customers but don't actually hold their securities, but they instead have those securities held at what's called a clearing broker that actually does sort of the back office work of holding the cash, holding the securities, making sure that the sales go to the buyers, that the cash comes to the sellers, et cetera, account statements, and it often has much more infrastructure. The introducing brokers, which are typically much smaller firms, less well capitalized, don't have that infrastructure. They can rely on the clearing firm's tools, right? The clearing firm may run exception reports for them, or may flag potential transactions for them to look at. But the introducing firms have their own independent responsibilities to perform STAR monitoring, reporting, and so they can't just defer to somebody else to perform those obligations for them.
I have a question that I'm going to direct to Ian first, and then we will invite the others on the panel to have a follow-up. Ian, what are the consequences of treating virtual currency reporting by way of a form similar to the FBAR and similar to the form for currency reporting transactions?
What it's going to mean is you're going to have a tremendous increased risk of one, regulatory enforcement. Two, if you don't comply, the foreign bank accounts have been. You can read in the advance sheets almost every day. There's another foreign bank account report case, and the foreign bank account setup, even if it's not criminal, the penalties are draconian. There's no reasonable cause exception, even though it's a Title 31 penalty, not a 26. And what they've done is the penalty. There's a negligence penalty, which is $10,000. Either account performed. There's a dispute around the country as to which. But for a willfulness penalty, which has been defined as just somebody acting recklessly, which means, depending on the circuit, something you knew or should have known, or something you could have learned easily. The penalty is either $100,000, whatever there's a higher, $100,000 or half the value of the account. So if you got $1 million in the account, your penalty can be $500,000 a year plus interest. And if they're going to apply this regime to crypto, it's going to be the same thing. The way it's right now, there's a checkoff box on your return, as there is for FBARs, if you have crypto, and you're deemed to know, in most of the circuits, you're deemed to know what's on the return, including the checkoff box of what you could have learned by reviewing. And the checkoff box is going to refer you, we assume, to the same thing that the foreign bank account is, which is a reporting form. And then if that's what they do, you're going to be deemed to know what's on the reporting form. It means if you don't file it, and you don't file for the right amount, you're going to be almost always at least reckless and therefore willful. So say you have $10 million of crypto for a year and you miss the form, you're looking at a $5 million penalty plus statute plus interest they can get once they get an enforcement order per year. There are cases out there where for the FBAR context, they've sought to obtain more than was in the account to start with because you have multiple years. So I'm not anticipating, it'll be good for for lawyers who work in the area, but I'm not anticipating it's going to be good for the taxpayers and the reporters. It's probably going to be a very onerous regime like the FBARs are.